Okay. All right. Good evening, everyone. My name is Adam Carson. I am an associate planner with the Rockland County Planning Department. I'm also the executive director of the Rockland Municipal Planning Federation. Also from the Rockland Planning Department is Rich Schaffo, principal planner. He's waiting in the wings in case of a catastrophic Wi-Fi disruption on my part. So you probably won't see him, hopefully, for the session. Welcome to session 2 of our certification series, the update of case law. The Rockland Municipal Planning Federation is a nonprofit organization that was formed over 33 years ago. One of its primary functions is to provide and promote educational programs for land use board members so that they can make more informed decisions regarding the development applications that come before them. The certification program dates back to 1993. At that time, the towns and villages in Rockland and the county itself agreed to require their ZBA and planning board members complete a specific training series created by the Federation. Board members in Rockland County must complete sessions 1, 2, and 3 to be certified and retake session 2, tonight's session, every other year for recertification. All 3 sessions are held in the spring, with a second session 2 being held in the fall, tonight. The county certification requirement predates and is independent of the New York State 4-hour training mandate, but don't worry, this session does apply towards that requirement as well. Before I begin, I have a few housekeeping items. Session 2 is unique among the various programs offered by the Federation in that attorneys can earn continuing legal education credits. The New York State CLE board has several requirements that I'm obligated to follow, the most significant of which is the use of attendance verification code words. I will provide these code words throughout the session. I strongly recommend that attorneys write them down. I will be giving the first one soon, so grab a pen and paper if you haven't already. Once I give them, I will not repeat them later in the session. If you are not an attorney seeking CLE credit, you can ignore them completely. Additionally, every attendee will receive a course evaluation form and an attorney affirmation form by email after the session. Again, if you are not an attorney seeking CLE credit, you do not have to return them. If you are an attorney and want CLE credit, you will have to complete the attorney affirmation form and return it to me. Next, the Federation maintains attendance records that we regularly share with towns and villages within Rockland County. So local board members usually do not need a certificate of attendance. But if you are on a board outside of Rockland County and need a certificate, please email a request to me that includes your name, municipality, and board. Please know you may not receive a response from me for several days. Lastly, all your microphones are muted. If you have a question, please type it into the Q&A function. I'll be monitoring the Q&A and I'll relay your questions to Attorney Addona periodically during the session. Please limit your questions to the cases being discussed or general areas of law. Christie is not in a position to give advice or opinions on specific projects or active legal actions in your community. As promised, I'm about to give the first attendance verification code word, and that is GHOST, as in Casper the Ghost. GHOST. If there are any fellow Wordle fans out there, you know that's a tough one. Anyway, so the first word was ghost. All right, moving on. Tonight's session, the update of case law, looks at some of the latest developments in land use law. We are very fortunate to have with us tonight attorney Christie Tomm Addona. Christie is a partner at Silverberg Zelantis LLC, where she works on litigation and appeals, as well as land use applications. She advises municipal boards, including those in the towns of Haverstraw and Ossining and the village of Tarrytown. She also counsels parties appearing before municipal land use boards. In addition, Christie has worked on a number of Article 78 proceedings, either defending or challenging administrative decisions. She further assists the firm's clients in drafting commercial contracts, including leases, contracts of sale, and construction contracts, advising on employment law issues and commercial litigation. Christie regularly lectures on zoning and land use topics and has been acknowledged in the 2018, 2019, 2020, 2021, and 2022 publications of New York Metro super lawyers as a rising star in the area of land use and zoning law. Prior to joining Silverberg Zelantis LLC, Christie was employed by civil litigation law firms and worked on cases from commencement of lawsuits through trial and appeal. Christie has worked for a variety of clients, including large corporate entities, not-for-profit corporations, and individuals. Her prior experience also includes insurance defense, tort, and maritime law. Christie received her Bachelor of Arts with majors in economics and history from Swarthmore College and graduated magna cum laude from St. John's University of Law. She is admitted to practice in New York, New Jersey, the Federal District Court of New Jersey, and the Federal Southern District of New York. So please join me in welcoming Christie, and thank you for being here once again.
Thanks, Adam. Thank you for all the work you do behind the scenes to put this all together, not just for this session, but for all the sessions. Good evening, everyone. So as per usual, I have a lot of content to get through. As Adam mentioned, I will stop periodically for questions. I'm going to share my screen now so that you can follow along with me on the handout. Adam, can you see that?
Yes, I can.
Okay, so this, which I believe was circulated to everyone previously. It's not as comprehensive a synopsis as what I'm going to go through with you here in person, but in the event I am not able to get to any of the cases due to time constraints, this does give you a pretty comprehensive overview of what the cases are. So with that, I am going to dive right in. So we start with site plan and special use permits. The first case, Barnes Road Area Neighborhood Association versus Planning Board of the Town of Sand Lake. And in this case, the property owner applied to the planning board for a special permit and site plan approval to construct a barn to operate as a seasonal party venue, which we've been seeing more frequently now that rustic venues are, I guess, trendy. And the planning board did grant it subject to certain conditions. A neighborhood association and its members brought an Article 78 proceeding challenging that approval. So first, the court identified the standard for a special permit, which is that a special permit use is tantamount to a legislative finding that the permitted use is in harmony with the general zoning plan and will not adversely affect the neighborhood. The court also made mention of the fact that there is considerable discretion that's afforded to municipal boards in evaluating each application for a special permit and to determine whether the conditions have been met and whether the application should be granted. Thus, the determination will only be annulled if it was arbitrary and capricious or an abuse of discretion or in violation of law. In this case, the court did uphold the granting of the special permit based upon certain findings that the planning board did consider the criteria for a special permit that was set forth in the code. The board also made note of the fact that there were other uses that were permitted as of right that didn't actually require a special use permit that would be more intensive and impactful than the proposed event venue use. The board had an expert report in the form of an engineering letter stating that noise and traffic would not be an issue. And the court also noted that the board received input from the public at the public hearings so that there was an opportunity for the public to weigh in during that process. So in light of the record before the court and the deferential standard afforded to land use boards, there was no basis to annul the approval, and the court upheld it. The next case, 1640 State Route 104 LLC versus Town of Ontario Planning Board. A property owner operated a nursery and landscaping business, and in 2018 obtained site plan approval from the planning board with certain conditions, including, and I'm going to quote because this is important, that, quote, the applicant may store wood stumps, limbs, and clippings to be regularly processed for landscape mulch. So the property owner got their site plan approval with this condition, and then they submitted another site plan application seeking to reconfigure the lot in order to expand their use. At this point, the town realized that in addition to just storing those materials, the applicant was actually mulching the materials on the property, which the property owner thought was allowed under the 2018 site plan approval, but the town determined required a special use permit as a light manufacturing use. So the applicant tried to go through the proper channels. They applied for a special permit, but the planning board actually denied it and made an interpretation of their prior resolution that the 2018 site plan approval did not allow mulching on the property. So the property owner brought an Article 78 proceeding challenging both the denial and the planning board's that its 2018 site plan approval resolution, which stated that certain materials could be stored in a certain location to be mulched, did not actually authorize the mulching itself. It was just stating what they were being stored for. It seems to be grasping at straws a little bit, but the court did end up upholding that determination, given the weight and deference that's afforded to planning boards, especially when looking and interpreting their own resolutions, which isn't something we really see very often in the case law. And then with respect to the special permit, the court acknowledged the standard that a special permit is tantamount to a legislative finding that the use is in harmony with the general zoning plan and won't adversely affect the neighborhood, but then went on to make clear that that doesn't mean there's an automatic entitlement to the special permit, and it's incumbent upon the property owner to demonstrate that the use conforms with the conditions and standards that are set forth in the code. And in any one case, if there's a failure to comply with even one condition of the code, then that's a basis to deny the application. And that provides a rational basis to justify the board doing so. And in that case, that's what the court found in this case, that the applicant couldn't demonstrate compliance with all of the conditions, even in light of the prior approvals and the fact that, there was at least some tangential reference to mulching occurring, and then upheld the planning board's denial of the special permit. So I think the takeaway in this is to just be careful with how you're wording your resolutions, especially when it comes to uses, instead of, qualifying what something is going to be used for, because in this case, it ended up causing a lot of trouble and a lot of litigation that went on for several years, because this goes back to 2018. And then the next case, 999 Hempstead Turnpike LLC versus Board of Appeals of the Town of Hempstead. A property owner applied to the town for a special permit and an area variance to construct a self-storage facility. So in this case, we're looking at state law, and it's state
Can you just
town
scroll
law.
down? Sorry.
Sorry about that.
Thank
We're looking at state town law, New York town law, section 267A, which regulates the procedure of the zoning board. And it states that a zoning board has to render a decision within 62 days of a public hearing. And then in a different subsection, it says that if the zoning board does not comply with that 62-day requirement, but with qualification, when acting in its appellate capacity, then it's deemed a default denial. So in this case, the applicant had made the application for both a special permit and an area variance from the zoning board. And the zoning board held a public hearing, closed the public hearing, and 62 days later, they still hadn't made a decision. So the applicant considered that a default denial and brought an Article 78 proceeding challenging the default denial and seeking to have that denial annulled as being arbitrary and capricious. So with respect to the challenge to the special permit, the court said the challenge was not actually ripe for review. So when the town law provision contemplated a default denial, it was only when the zoning board is acting in its appellate capacity with its appellate jurisdiction, meaning you're appealing a determination that has been made by the building inspector or the building department or the zoning official. So that's your interpretations, that's your area variances, that's your use variances. So in that case, if a decision isn't made within 62 days, then it's deemed a default denial. Here, the authority for the zoning board to issue a special permit was in its original jurisdiction, because that was authority that was given to it under the code by the local legislative board, that the zoning board had the authority to grant this special permit. So that default denial provision did not apply to the special permit. And as a result, there hadn't been no default denial. And so it wasn't right for review by the courts because there hadn't been a final determination. And we'll talk more about ripeness later. But so you have to be aware of in what capacity the boards are acting, because it can be very nuanced in the case, in the context of what rules may apply in specific situations. And this applicant, was very diligent and probably thought they were doing the right thing by moving quickly to challenge the default denial, only to spend years in court and be told there's nothing for the court to decide right now, go back to the zoning board. So that is it for site plan and special permit. Moving on to area variances. Dutt versus Bowers. A property owner had hired a contractor to install an in-ground pool. The pool required a 14-foot setback from the property line under the zoning code, but the contractor apparently only installed it 6 feet from the property line. It's a pretty substantial deviation. So then the property owner made an application to the zoning board for a variance to legalize the location of the pool located within the setback. The zoning board actually denied the application, and the property owner brought an Article 78 challenging the denial. And so I'm just going to use this case as an opportunity to briefly go through the standard for an area variance, which the court lays out in detail. When a zoning board of appeals makes a determination of whether to grant an area variance to an applicant, the zoning board is required to engage in a balancing test, weighing the benefit of the grant to the applicant against the detriment to the health, safety, and welfare of the neighborhood or community if the variance is granted. A zoning board must consider the following factors when making its determination. 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by granting the variance. 2, whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. 3, whether the requested variance is substantial. 4, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood or district. And 5, whether the alleged difficulty was self-created, which determination of being self-created is not determinative in this case. And the court noted in applying the deferential standard that's afforded to the zoning board in this situation, it upheld the denial of the area variances. And the court went through the zoning board's findings in this situation, which noted that there would be an undesirable change in the character of the neighborhood because there were no similarly situated in-ground pools. Also, approving a pool with such a small setback would establish an unwarranted and negative precedent for future development in the area, which could also result in a detriment to nearby properties. The court also noted that the pool could have been placed in a conforming location, and there was no evidence that the property could not be utilized without complying with the code. The court recognized the ZBA's acknowledgement that the variance was substantial at 57%. And lastly, even though the property owner claimed that this was the contractor's fault, the court found that the ZBA's determination that the need for the variance was self-created was well-founded. So that should be a little bit startling, you know, if what the property owner said is what actually happened, then this wasn't their fault. The contractor made a mistake, but because it was an agent or representative of the applicant, the ZBA and the court both found that that still constituted a self-created hardship, which certainly weighed against them in this situation. So, and I just want to make clear, I do this at least once every time I do these sessions, that one of the things about this case was that there was a very hefty record. The zoning board had made a very detailed analysis of why they made the decision that they made, and that made it very easy for the court to extrapolate those reasons and to hang its hat on when upholding the zoning board's decision. So it's just something to keep in mind when you municipal board members are issuing your own decisions. Not only, as we saw in the other case, be careful about how things are worded, but also try to be as expansive as possible, because the court is only going to be able to look at what was in the record and what your findings were. And so there's no depositions, there's no trial for cases like this involving Article 78 proceedings. So when you're doing these things, you want to be basically writing to the court in case you do end up having to defend it at a later date.
Christie, there was a question about this case. What was the role of the building inspector in ongoing observation and litigation?
A lot of these cases don't get into that level of detail. It seems that the building, generally as it works in municipalities, the building inspector would have been the one to realize the issue when the construction was completed. It's unclear if there had been ongoing inspections of the property, and at one point it came to the municipality's attention that this was an issue. But that's one of the problems with these cases, is that because they're at the appellate level, a lot of times they don't have the level of factual insight that you may see in other cases, if at all. And so it's more for the concepts, and so unfortunately I can't answer that definitively. So the next case is Sticks and Stones Holding LLC versus Zoning Board of Appeals of the Town of Milton. Petitioner had purchased a 3-acre property at a foreclosure sale that contained a dilapidated mobile home and multiple human burial sites. He sought an area variance to construct a 2,500 square foot home where the minimum lot acreage was 5 acres and this property was only 3 acres. The zoning board denied the variance and the petitioner brought an Article 78 proceeding challenging the denial. The court did go through the standard for an area variance, which I'm not going to repeat again. And then also noted that the zoning board is not required to justify its determination with supporting evidence as to each of the 5 factors, as long as its ultimate determination reveals that the balancing test of the relevant considerations was rational. So what the court's looking for here more, they do give the criteria, and I do recommend that you address all of the criteria, but what they're looking for more is a balancing of the interests and the considerations that are set forth in that criteria. And based upon that, the court upheld the zoning board's denial of the area variance. The court noted that the zoning board had repeatedly requested that petitioner provide an inventory of the burial sites, allow the town historian to take photographs of the gravestones, and to take other measures to protect the burial sites. The State Office of Parks, Recreation, and Historic Preservation also made some recommendations, which the applicant did agree to comply with, but the applicant would not agree to any of the requests or recommendations that had been made by the zoning board, and also refused to allow access to the property to inspect those burial sites. So in light of this, the court found that it was reasonable for the zoning board to conclude there would be a detrimental impact from granting the variance. Because of the location of the burial sites couldn't be properly determined because of the applicant's lack of cooperation, the zoning board couldn't determine whether a code compliant well and septic system could be utilized for the larger residential structure without impacting the burial sites. And for these reasons, the court found that the zoning board did engage in the requisite balancing test and rationally determined that the detriment to the health, safety, and welfare outweighed the benefit from the granting of variance. And in this case, it's kind of the inverse of the prior case, where what the zoning board relied upon to support its determination was the lack of information in the record, because that information wasn't provided by the applicant. You know, sometimes applicants may think that it's gonna create more trouble to provide certain information, but if you don't, then, you know, it kind of puts the board in a difficult position.
Christie, if I could just back up for 1 second. I think a couple of people asked about the pool and whether it ultimately had to be moved.
That would be the ultimate outcome. If they don't have a variance, it can't be there. I guess the other thing, you know, there are multiple, in addition to seeking a variance to legalize it, if they don't, then the next step would be for some sort of enforcement action, which would be in the municipal court. And then that would have to be resolved through the court system, either through penalties or through removal. But without the variance, and with the court upholding the denial of the variance, there is nothing to legally allow the pool to remain in that location.
I think that particular case, you know, kind of brings up the larger issue of, you know, these decisions will have serious impacts on people, and a denial is something that, you know, as a homeowner, you have invested money and now you're losing it.
Well, I would say hopefully that contractor has good insurance, because, you know, if I'm the property owner, then hopefully that's who paid for this entire litigation, and that's who I'm going after, if that's actually what happened. You know, that there are obviously also situations where you ask for forgiveness instead of permission. You just do it. Either you don't realize you need approvals, which you're presumed to know under the code, but either you don't know, or you just say, you know, I'll just figure it out later. But boards don't take too kindly to that, because it does really tie their hands in a lot of situations. And I was surprised that there was a denial, because, you know, these are also people on the boards. So, you know, I could see there being sympathy for someone in this situation, but the zoning board had rational reasons for their determination, and the precedent was a big one. And if you let it go for this one, what's going to happen next time? So the next case is Humphreys versus Somers Zoning Board of Appeals.
You could just scroll down too, please. With
Yep.
that. Thank you.
And in this case, the applicant owned 12 acres in a residential district. The code allowed a barn with up to 2 horses and it separately allowed human habitation in a barn that was built before 1992, but it prohibited a barn from housing both animals and people. The applicant in this case wanted to construct a new barn that housed 6 horses and had an accessory apartment on the 2nd floor. I can't imagine what it would be like to live above 6 horses, but presumably there's a market for that. So the zoning board granted the area variances and a special use permit for the use, and the neighboring property owners challenged the approvals. And so the issue in this case was that the neighbors claimed that this was actually a use variance and not an area variance. And as we'll discuss in a minute, the standard for a use variance is much more difficult to satisfy than an area variance. In this case, the applicant needed a variance to allow 6 horses where only 2 were permitted, to allow a residence in an accessory barn built after 1992, and to allow animal habitation and human habitation in the same structure, none of which was authorized by the code. But the court determined that because the applicants were not seeking to, quote, change the essential use of the property, the zoning board properly considered it as an area variance, and not a use variance. The court didn't really explore this in greater depth other than to say that it was focused, it didn't change the use of the property. But this is an issue that does come up from time to time as to whether something is an area variance or a use variance. And if you're an applicant, you always want it to be an area variance because of how much more challenging it is to satisfy the use variance standards. And presumably that's why the neighbors made that argument, because the property owner likely would not have been able to satisfy that standard. But in this case, the court, presumably giving discretion to the zoning board as is authorized when they're interpreting the code, upheld that it was an area variance and upheld the zoning board's granting of the area variance. So now on to use variances. Gidney versus Zoning Board of Appeals of the City of Buffalo. So the property owner owns several contiguous parcels that were split between 2 zoning districts, a mixed use district, so that's a combination of residential and commercial, and a residential zoning district. And in order to construct a proposed 133 multifamily residential development, they needed a use variance. The zoning board granted the use variance, which is pretty rare. Generally, use variances are very hard to come by, and that's because of the standard. It's not a balancing test like an area variance. You have to satisfy all of the criteria, and they're more stringent criteria because basically you're asking to use the property in a manner that's not permitted by the zoning code. And the criteria for the area variance, use variance, are that the applicant can't realize a reasonable rate of return if the property is used for any use permitted under the current zoning, which proof must be demonstrated through competent evidence, which is essentially dollars and cents proof. So property owners aren't entitled to the highest and best use of their property under this concept, just a reasonable rate of return. And they have to show that they won't be able to get that through any of the uses that are permitted in the zoning district. And you have to provide competent financial data to demonstrate that. So that's generally very hard. And even when we do see use variance cases where the application is denied, rarely do they even address all 4 of the criteria, because applicants rarely get past this first hurdle. But then the other 3 are that the hardship results from unique characteristics of the property, namely that other property owners will not be able to rely upon the situation to get a similar use variance for their property. So you want to make sure the situation is unique. Again, this goes back to the concept of precedent that we mentioned earlier. The proposed use would not alter the essential character of the neighborhood, and the hardship has not been self-created. And unlike with an area variance, self-created hardship is determinative. So if it's self-created, again, that knocks you out. You can't get a variance. So in this case, the court did note again the considerable deference that's afforded to zoning boards, and did actually uphold the granting of the use variance. There wasn't a lot of analysis of what the zoning board's findings were, but the court did make note of the fact that they could not otherwise earn a reasonable rate of return. The hardship was unique, and the variances would not alter the essential character of the neighborhood. The next case is Bateri versus Zoning Board of Appeals of Town of Kent. A commercial property had been used as a concrete batch plant since at least 1949. Pursuant to the zoning code that was enacted in 1937, the property could not be used to manufacture products like concrete unless certain conditions were met, which included that there were fewer than 5 employees engaged in the work. However, the property had been granted a variance by the zoning board in 1948 to allow the then owner to employ more than 5 people in the operation of the concrete plant. So Kent investors purchased the property in 2016 and intended to refurbish the building and restart the concrete plant operations. And then in 2017, the building inspector determined that the use was no longer allowed because he believed the use was pre-existing non-conforming. And with pre-existing non-conforming uses, that generally they are allowed to continue as long as they're operating. But once they cease for a certain period of time, and this is generally regulated in local zoning codes, and the amount of time could vary. It could be 6 months, it could be a year, it could be 2 years. But if the pre-existing non-conforming use ceases for that designated period of time, then the use lapses, and any further use of the property would have to be in conformance with the current requirements of the code. So that was the building inspector's perspective, that this use the concrete plant hadn't been operating for so long that the use was no longer permitted, and they could only operate permitted use in the district. However, at this point, the applicant did find this variance that was issued back in the 1940s that allowed the use for the property with more than 5 employees, which he argued was a use variance that ran with the land, meaning that it could operate in perpetuity and wasn't subject to those lapse provisions that generally apply to pre-existing non-conforming uses. The building inspector maintained his position that it was a lapse pre-existing non-conforming use. So the applicant went to the zoning board and actually convinced the zoning board that it was a use variance, and so it could continue to operate. So then neighboring property owners went to court challenging that determination that it was a use variance and that the use could continue to operate. One of the things that the neighbors raised, separate and apart from the issue with the use variance itself, was the record. So when you have an Article 78 proceeding, as I mentioned earlier, you don't do depositions, discovery, trial like you would with other types of litigation. You just have the record. You have everything that was before the board in making their decision, because the court's review is limited to looking at what the board did and making sure it was rational, making sure it wasn't arbitrary and capricious and abuse of discretion. So the court doesn't want to see anything that the board didn't see, because that could influence the court's judgment. And the court's only supposed to be making its determination based upon the reasoning that the zoning board made its determination. So in this case, the neighbors wanted included in the certified record that went to the court a prior appeal that had been submitted with respect to this property. And the court said no, because you guys didn't submit that to the zoning board. No one submitted that to the zoning board. So the court shouldn't have it, because then the court is looking at information that the zoning board didn't have, and that dehors the administrative record. So after addressing that issue, the court actually couldn't rule on the merits of this case, because what had happened at the lower court was that the lower court had dismissed the case, saying that the petitioners, the neighbors, didn't have standing to challenge the case. And I'll talk about that in a couple of minutes, but that's a threshold issue where if you don't have standing, the courts aren't even going to look to the merits. So the lower court dismissed it for lack of standing. The appellate court reversed that and said, no, I think they do have standing. But since the lower court had never analyzed the merits of the appeal, the appellate division didn't do that on its own volition and sent it back. So who knows? We may be seeing this case again in a few years on the merits. So the next case, Titan Concrete Inc. versus Town of Kent, I'm going to skip in the interest of time. It's not really a use variance case. It's related to the Viteri case that I just talked about. The town board ultimately, after that determination by the zoning board, enacted a law that prohibited concrete plants, but allowed a sunset period to allow such uses to continue for 2 years. However, the court ultimately invalidated the local law because the supervisor was a member of one of the entities that was the petitioner challenging the zoning board's determination. And so the supervisor had a conflict and did recuse herself from voting on the local law, but didn't recuse herself from the proceedings entirely, as she continued to preside over the public hearings, engaged in discussions, joined the rest of the board in executive session and voted on certain items. So the court found that her involvement had tainted the process to the extent that the local law was invalid.
Okay. There's a question about difference between use and area variances. Can a use variance be used as a precedent for an area variance, or are they completely separate?
Yeah, they're completely different things. So an area variance deals with bulk regulations, size, setbacks, floor area ratio, height, stuff like that. Whereas use variance is what it says. It deals with the use. So, and the considerations are completely different. So one, I can't really imagine a situation where one would set a precedent for the other. But that's not to say that area variances and use variances separately can't set precedent for subsequent applications of the same kind.
I just also, one issue that I've seen with use variances is very often when you have bulk regulations that are specific to a use within a district, and you have a use variance, the question becomes, what bulk standards do you apply for something that's not listed as one of the allowed uses?
That is a challenge. I mean, I think generally you would want to look at bulk regulations that are as comparable to the use as possible, right? So if you're getting a use variance to put an office building in a residential district, exactly right, it wouldn't make sense to apply the bulk regulations for a single family home. But you could then, I guess, look at the code and see, what do we require for similar types of uses. Okay, so the next topic, only one case, the building department, E&S Realty LLC versus Board of Appeals of Village of Sands Point.
Before you get started, Christie,
Yep.
I think I need to interrupt for another attendance verification code word. So all you attorneys out there looking for CLE credit, please write down the next word, which is pirate, as in Pirates of the Caribbean. If you're sensing a theme here, it makes coming up with random words easier. Come up with a theme. So the second attendance verification word for CLE credit is pirate. Okay. And don't need to repeat it in chat. That's just for the seat. Make sure attorneys are paying attention. Thank you.
So the next case, E&S Realty. Petitioner owned a residential property with an accessory structure. In 2016, the petitioner had applied for a building permit to enlarge and renovate the structure. A building permit was issued by the building department, and the improvements were made at substantial cost to the property owner. And after the improvements were done, petitioners went back to the building department seeking a certificate of completion for the improvements. It is only at that point that the building department realized that the accessory structure was being used as a residence, which had been prohibited by local law since 1989. So as a result, the building department would not issue the certificate of completion, and the petitioner sought a variance from the zoning board. It doesn't specify which kind, but I would imagine this would be a use variance, and that was denied. And petitioner then brought an Article 78 proceeding challenging the denial. So the reason why it didn't address the variance was because the focus of this issue was on the status of the property and the building department's prior actions. So the applicant had argued that this was a legal non-conforming use because claiming that the property had existed with this residential use in the accessory structure prior to 1989. And the court rejected that because the record before the zoning board had demonstrated that it was not being used prior to that time. And for legal non-conforming uses, the obligation is on the property owner to demonstrate. It's not on the zoning board to establish it isn't a legal non-conforming use. So the default is that you're not allowed to do this. And then if the applicant can demonstrate there's a reason why they can, that's one thing. But so the zoning board was able to show that the documentation showed that the property wasn't being used for that accessory residential use in 1989, and therefore it wasn't legal non-conforming. The next argument the petitioner made was that they were entitled to continue the residential use under the doctrine of equitable estoppel, which is when a municipality is precluded from taking a certain position based upon past actions. And so in this case, it was rational to argue, well, the building department gave me my building permit. They said I could do this, and I did it, and I spent a heck of a lot of money doing so. So, it's only fair that I be able to continue this use. And the court said no. The general rule is that a mistaken or erroneous issuance of a permit does not stop a municipality from correcting its errors, even when there are harsh results. So the equitable estoppel is really supposed to be used sparingly in exceptional circumstances where you can demonstrate some sort of bad faith on the part of the municipality. What the examples were: fraud, deception, or malfeasance. So the general rule is that municipalities have a lot of discretion and latitude to correct their quote unquote mistakes over time. And that can take a lot of forms. If there's an interpretation of use is permitted, and then another building inspector comes in 10 years later and says, no, that's not correct. Or, someone issues a building permit with setbacks that don't comply with the code, the building department is allowed to correct their mistakes. And it can be detrimental to the property owner who, thinks they're doing everything right and going through the proper channels, only to be told that they're not allowed to do that. So it's really incumbent upon property owners to make sure what you're doing follows the rules, because, you may skirt by once, but, that it could always come back to bite you later on, and you just never know. So you just want to make sure that you know what the rules are and that you're following them.
Excuse me, there's a couple of questions, and I'm going to jump around a little bit, but I think one was asking about the building inspector, I presume in this case, being subject to a legal liability.
No, municipal officials have qualified immunity. Otherwise, no one would ever do that job. So unless you can show some sort of bad faith or intentional wrongful act, someone could try to sue the building inspector. But look, in all of these cases, it's people suing zoning boards, planning boards, building departments, town boards, and if all of these people in all of these litigations were at risk of being held potentially personally liable, no one would ever do this job. And, obviously there's enough case law to demonstrate that this has been an issue in the past where people make mistakes because they're people. So, unless there was some sort of bad faith or malfeasance, which the court found there was no evidence of, there would be no personal liability.
There was a follow-up asking if there could be a reprimand. I think that would be a separate question.
I mean, that's up to the municipality and the circumstances of the case. I'm confined to what the case tells me, which doesn't really get into that. Okay. But, they're employees like everyone else.
I mean, not doing your job badly can have consequences no matter where you are, I guess.
Yeah.
There were two questions about non-conforming uses. One, if a restaurant in a non-conforming zone was closed for several years but maintained its liquor license, would it be considered as evidence of continuing use? And there's a similar question asking in the chat about a residential college of several buildings that discontinues regular classes and uses a few classrooms for conferences. Is that enough to keep the non-conforming use alive?
Those are really fact specific, and it's hard to say. Any sort of evidence that you can present will bolster your case. But there's a lot of factor that's a very fact specific determination. And so it's hard to say based upon having a liquor license what a board would determine. But what I will say is that, based upon these cases, boards are entitled to considerable deference in their decision in the courts. So, if you want to get the board on your side, because it's a lot harder to have the court overturn the board once they get there.
I feel like there was in a previous session that you did, there was a case with a gas station that was required to shut down for some kind of remediation or repairs. And
well, generally in the code, they'll contemplate different scenarios. So, and there's legal non-conforming uses, and then there's being legal non-conforming as to bulk regulations. So, and the code may regulate those to a certain extent. So I think if you have damage to the property, I think in most situations, unless it's completely demolished, you're allowed to rebuild if it's legal non-conforming as to bulk. if it's legal nonconforming as to use and you're required to shut down for reasons that are beyond your control or instead extenuating circumstances, that could be an argument. But the general premise is that you don't want legal nonconforming uses. You allow them to remain because out of fairness, because they existed before the regulations were put in place. But the ultimate goal and the intent of having these lapse provisions is that eventually these properties do come into compliance with the requirements of the code.
We're getting a lot of questions, which is great, and I love having people engage. But Christie, if you think that we're spending too much time on something, feel free to
I mean, I do have a heck of a lot to get through.
I mean, there is one question which I think is an interesting one. It was about the horse farm. The distinction between 2 and 6 horses is considered an area issue. It feels more like an intensity of use, which aligns more closely to a use variance. Is it because the number of horses is quantifiable, therefore numeric, and therefore closer to a measurement on the bulk tables?
Well, I mean, if you're talking about intensity of use, you can have an FAR that you double, right? That's going to increase your intensity of use, and that's an area variance. So yeah, I think it's, I think that that was a close issue, as in the case with the horses, as to whether it was an area or use variance. And whichever way the zoning board went, the court probably would have upheld it. But in that case, and again, for reasons that really weren't enumerated in great detail in the decision, the zoning board did decide to go with area variance. But yes, I do believe it's because it equates more to, it doesn't change the essential use of the property is what the code said, right? So you're allowed to have horses. So they're just saying, we're going to have more horses. So it's not like you're asking to house horses where horses aren't permitted. That, I think, would be more akin to a use variance. All right, so let me try to get through a couple of these sections because I'm very likely to run out of time. 61 Crown Street LLC versus City of Kingston Common Council. The city had created a mixed-use overlay zoning district in the downtown area for potential redevelopment. A developer proposed a mixed-use development of residential housing, parking garage, hotel, retail space, and pedestrian accommodations. However, a portion of the property that they wanted to use for this redevelopment was not in the mixed-use overlay district. So they made an application to the Common Council of the city to rezone that property to have the overlay district apply to it as well. And just briefly, an overlay district is in addition to the zoning that's in place. So in this case, the property was in a C2 commercial district, but then I guess as part of the comprehensive plan, when the city was looking at potential redevelopment, they created this overlay district that kind of sits on top of these properties and can be used in addition to the general commercial district. So that's what they were asking for in this case, to have that overlay district applied to this property as well. So the Common Council did SECRA and then approved the zoning change. And the petitioners, neighboring property owners, commenced the litigation challenging that. And they argued first that it was spot zoning. So spot zoning, is I think a term that scares people a lot, but it's pretty specific in its application. And it's the process of singling out a small parcel of land for a use classification, totally different from that of the surrounding area for the benefit of the owner of said property to the detriment of the other owners. And in evaluating a claim of spot zoning, courts will consider several factors, including whether the rezoning is consistent with a comprehensive land use plan, whether it's compatible with other surrounding uses, the likelihood of harm to surrounding properties, the availability and suitability of other parcels, and the recommendations of professional planning staff. But the ultimate consideration is whether the challenged zoning is other than part of a well-considered and comprehensive plan calculated to serve the general welfare of the community. And in this case, the court determined that it was not spot zoning. And the court focused on the fact that the parcel was actually contiguous to the other parcels that were already in the overlay zone. So it wasn't like this parcel was completely removed from the other properties in the overlay zone and just plopped down there. It was contiguous to and right next to which is why it was part of this development proposal in the first place. And the city's comprehensive plan actually contemplated allowing these type of mixed uses in the C2 zoning district where the property was located. And the court had also noted that during the seeker review, all of these issues, including analyzing any adverse impacts, had been looked at as part of the proposed project. The other issue that was raised was that a different parcel that was already in the overlay zone that was city owned was actually parkland. And so the reason why this is an issue is because parkland is protected by the public trust doctrine, which prohibits municipality from alienating dedicated parkland for non-park purposes without approval from the state legislature. So the issue in this case was it parkland, and how do you determine that? So parkland can either be dedicated express or implied. Express is pretty clear. There has to be some sort of resolution, declaration by the municipality that this is parkland and we tend to use it that way in perpetuity. There was nothing of the sort here. So then they looked at whether it could be parkland by implication. And in doing so, you have to consider the acts and declarations of the land owned, indicating the intent to dedicate its land to the public use, are unmistakable in their purpose and decisive in their character to have the effect of a dedication. So they want something, pretty definitive to prove that this is supposed to be parkland. And then that the public has accepted the land as dedicated to a public use. So like I said, there was no express dedication here. And with respect to an implied dedication, there were a couple of facts that the petitioners were able to point to support that this was parkland. There were public events that were held on that area, but they were temporary and sporadic. The public would use it to sit and eat lunch because there were some benches and picnic tables that were there. There was also a planter and a hopscotch board. And in the environmental assessment form that the applicant had submitted, they actually identified the parcel as a park. But despite all of that, and acknowledging that there were some park-like attributes, the court said there wasn't a clear implication of dedication because there wasn't sufficient evidence of a clear intent on the part of the city to permanently treat the land as parkland. And then the court addressed some of the issues that petitioner had raised. And the court said, the EAF, which I'm going to talk about in a few minutes, as part of the seeker process, was prepared by the applicant and not the city. So that doesn't demonstrate the city's intent with respect to that parcel. And basically what the court said is people can sit and eat lunch anywhere. And so just because you're doing it, on this bench doesn't make it a park. It just makes it public space where people can be. And one doesn't necessarily equate to the other. Okay. So threshold issues. You know what, I'm going to run through these first two really quickly. So this is what we were talking about earlier with standing, where these are issues that if they're raised at the outset of a litigation, they have to be resolved. And if you can't resolve them in the petitioner or the plaintiff's favor, the court isn't even going to look at the merits of your claim. So these get you into the door to the courthouse. So the first case is Greenville Fire District versus Zoning Board of Appeals of the town of Greenburgh. A developer made an application to the town of Greenburgh to construct an assisted living facility. The application required area variances from the ZBA, as well as a special permit from the town board. The zoning board served as lead agency pursuant to SECRA, which we'll talk about in a little bit. And what's important in this situation, whenever you're dealing with statute of limitations, are the dates. So in this case, on April 24th, the zoning board issued a negative declaration, which ends the SECRA process. And then on June 22nd, the zoning board voted to grant the area variances. On June 27th, the results of the June 22nd meeting were filed with the town clerk. But then it wasn't until almost 3 weeks later, on July 13th, that what they called a certification of decision, which set forth the CBA findings, was filed with the town clerk. So the statute of limitations is 30 days. So the question is, what is it 30 days from? And the general rule is that it's 30 days from the filing of the decision with the clerk. I generally err on the side of the earliest possible date, which is the date that the decision is made, because, you know, you're better off being told you're too early than too late, because you can always come back, but once you're too late, you can't come back. So in this case, it was 30 days, and the Greenville Fire District, which was concerned about this project and potential impacts it could have, brought a litigation on August 11th, which was less than 30 days from July 13th, when the certification of the decision had been filed with the clerk. However, the court found that the statute of limitations had actually began to run on June 27th, when the results of the meeting, which memorialized the zoning board's determination and recorded the vote of each of the members, had been filed with the clerk. And so because the litigation was commenced more than 30 days after that time, it didn't comply with the statute of limitations. And this is something where courts have no discretion. They can't sympathize with you. They can't, you know, give you a break. If you don't comply with statute of limitations, there's nothing that can be done. So in this case, because the court found that the statute of limitations commenced with the filing of the results as opposed to the filing of the certification, which honestly, the applicant, the fire district may not have even known that the results were filed with the clerk. If it was just, you know, a one-sheet piece of paper, but that's what started the statute of limitations. And so the court said that the challenge to the variances was barred and was time barred and did not consider the merits. So the other issue is how this relates to secret. So the secret statute of limitations does not commence necessarily with the issuance of the negative declaration. When it does commence is when there's a decision that renders the final consideration of secret issues. So generally, it's the first land use approval or decision subsequent to the secret determination. In this case, that was the zoning board granting the variances. So in the same litigation where the fire district challenged the variances, they also challenged the secret determination. But because the time to challenge the variances wasn't timely, and because it correlated with the time to challenge the secret determination, both of them were untimely, and they were both thrown out without a consideration of the merits. And then the next related case is also Greenville Fire District versus Town Board of the Town of Greenburgh. So as I mentioned, in addition to needing variances, the applicant also needed a special permit from the town board, and they did obtain that in February of 2018. So that was several months after the secret determination and the zoning board granting the variances. So in March 2018, the fire district commenced another Article 78 proceeding challenging the determination to grant the special permit. And in this time there was no question that it was timely commenced. However, perhaps realizing or knowing, although I don't think a decision had been rendered in the other action yet, that they hadn't timely challenged the secret determination, they tried to piggyback that into their challenge of the town board's issuance of the special permit. In this case, the court said no, not on the basis of statute of limitations directly, but on the grounds of res judicata. So res judicata is a concept that precludes a party from litigating a claim where a judgment on the merits exists from a prior action between the same parties involving the same subject matter. And this rule also applies to claims that could have been raised in a prior litigation. So because the prior action challenging the zoning board variances involved the same parties, namely the zoning board and the fire district, petitioners could have raised it in that litigation, which they did, but it wasn't within the statute of limitations. So as a result, the petitioners were still barred from relitigating that issue, even though the court had never actually considered the merits of it in the prior litigation. And with respect to, but even, throwing out again the challenge to the secret determination, there was still the Article 78 proceeding against the town board challenging the special permit that was timely filed. And that was resolved by the court dismissing it for lack of the petitioner's standing. And in this case, the court found the fire district's concerns regarding an increase in the number of emergency calls during the construction and the need for additional personnel and equipment to adequately provide services were outside the zone of interest that the zoning code was intended to protect. Further, the court found that allegations that the special permit may result in road safety hazards were too conclusory and speculative, and therefore did not establish standing. So all in all, you had two litigations, and petitioner never even got to hear the court hear their claims on the merits. So the next case is 505 Northern Boulevard versus Unincorporated Village of Old Brookville. Petitioner submitted a building permit application to operate a gas station on his property. The building inspector denied the application on the grounds that is this the case you were talking about, Adam? This may be the case you were talking about. On the grounds that the gas station use was legal non-conforming because it had been abandoned under the zoning code. And under this particular zoning code, the issue was that the legal non-conforming use had been discontinued for a period of 1 year, and therefore it couldn't be reestablished. The reason why I didn't think of it when you mentioned that is because the issue in this case is kind of different, because the focus is on what the applicant didn't do, which is the applicant had this determination from the building department that the legal non-conforming use had lapsed, so they couldn't use it for that purpose and had to use it for a purpose that was permitted by the code. So normally in this process, you would go to the zoning board and appeal that interpretation and try to get the zoning board to agree and overturn that. This applicant didn't do that. They went straight to court. And so the court said it is Hornbook law that one who objects to the act of an administrative agency must exhaust available administrative remedies before being permitted to litigate in a court of law. In this case, that meant petitioner should have appealed to the zoning board because they could have given him the relief that he was ultimately seeking from the court. And that's why you have that extra layer of relief, so that all of these things don't go directly to court. However, unlike statute of limitations, this is not a hard and fast rule, and there are exceptions, such as when the action being challenged is unconstitutional or wholly beyond its grant of power, or when the administrative remedy would be futile or pursuing it would cause irreparable injury. However, the court found that none of these exceptions were applicable here. The court rejected petitioner's claim that the building inspector's determination constituted an unconstitutional taking of his property. First of all, the court noted that a constitutional claim is a factual issue that could have been reviewed at the zoning board had they taken the appropriate route, but it wasn't. And also, the court made clear that you can't just throw your hands up and say constitutional violation, constitutional taking in order to get around exhausting your administrative remedies. You actually have to have merit to that claim and be able to corroborate and support why you're saying that. And in this case, there was nothing in the record. And so like in the prior cases, the applicant's claim was thrown out without the court even considering the merits of it. And at that point, the time to go to the zoning board would have long passed, because generally in most municipalities, it's 60 days. And then the last case is 61 Crown Street LLC versus New York State Office of Parks, Recreation, and Historic Preservation. This case is actually related to the case we talked about earlier in Kingston with the alienation of parkland and spot zoning for the overlay zone for redevelopment. So in this case, the petitioners had challenged a letter that had been issued by the State Office of Parks and Recreation and Historical Preservation, determining that the proposed development would not have an adverse impact on the historic district the property was located in. So this was a letter that had been submitted as part of SECRA, because SHPO for short, it was an involved agency, I believe because of certain funding that they were getting for the project. So SHPO had originally raised some concerns, and then the applicant made changes to the project, and then they ultimately determined that this was, with the changes, it would not have any adverse impacts. So then petitioners weren't happy about that because they were opposing the project. So they actually brought an Article 78 proceeding, basically seeking to compel SHPO to change its determination and also to explore certain alternatives to the project. And in this case, the court dismissed the claims on the grounds that petitioners didn't have standing to challenge the determination. And I know we've talked about standing a few times already, but to establish standing to challenge a government action, the party asserting standing must show first an injury in fact, and second, that the injury falls within the zone of interest or concerns sought to be promoted or protected by the statutory provision. And the court first rejected that petitioners had presumptive standing because they own property in close proximity to the project. So petitioners had to demonstrate an actual and specific injury different from the type of injury suffered by the general public, which injury is within the zone of interest of the relevant statutory provisions. So what's kind of unique about this case is that generally when we talk about standing and being within the zone of interest of the statutory provisions, you're generally looking at either the provisions of the zoning code regulating variances, site plan, subdivision, etc., or you're looking at the seeker regulations. In this case, you were actually looking at historic preservation statutes to preserve and protect property that's located in historic districts. So that kind of narrowed the scope of the types of harm that petitioners could allege while still being within the zone of interest of the statute intent that is at issue. So here, the injuries that were alleged by petitioners that related to the protection of historic property were either too general to be different from an injury to the public at large, or not specifically related to the historic nature of the property, such as claims of economic harm or harm to the views. So economic harm is actually something that comes up a lot in seeker, but that's really not within the scope of seeker's, what it's intended to protect. It's an environmental law, it's environmental regulation. So we see often, and in this case too, the argument is for economic harms, and that's not within the scope. So that does not confer standing for someone to come in and challenge the determination of this case of the State Office of Historic Preservation. The goal is you want the court addressing issues that are actually relevant and that someone actually has a basis to raise, because the courts are already as overcrowded as it is. And if anyone could just go into courts, challenge anything for any reason, it would just be untenable. Do you want to take a few questions, Adam? Are there any?
I was muted, sorry. I don't see any in the chat right now.
Okay.
Just or the Q&A, which is a little bit of a better mechanism for answering questions, because the chats gets very crowded and I probably missed something somewhere along the way in the chat box, but Q&A, the questions stay there until they're answered. But right now I don't have anything.
Okay.
I could, but I could do another code word though.
Okay.
It's a little early. So the third CLE code word of the night is costume. On Halloween, children will go around wearing a costume. Okay, again, this is just for attorneys who want continuing legal education credit. If you are not an attorney, don't worry about it. Thank you.
Okay, SECRA, State Environmental Quality Review Act. So this is state law and regulations that have to be complied with before any sort of discretionary action with respect to a land use development can be made. So before site plan approval, before subdivision, before variances, there has to be at least some acknowledgement of SECRA, even if it's just to say SECRA doesn't apply. And so the first issue, which I think is kind of interesting for land use cases, I guess, is that there were 3 cases this time where someone was challenging the typing, so to speak, of the action. So there are 3 types of actions: type 1, type 2, and unlisted. Type 2 is a list of actions the DEC has determined are not going to have, as a matter of law, significant adverse environmental impact, and therefore you don't need to do any sort of environmental review. Conversely, or inversely, excuse me, type 1 actions are those that are presumed to have at least one potential adverse environmental impact. That's not definitive, but that's what that list kind of indicates. And then unlisted is exactly what it means, everything in between. And so there are different requirements for each of these types of actions. So the first case is Capitano versus Town Board of the Town of Brookhaven. Petitioners commenced a proceeding to challenge the town board's determination that the town's proposed condemnation of an easement was a type 2 action under SECRA, which is exempt from environmental review. Petitioners argue that the project would have a significant effect on environmental conditions and that the type 2 classification was improper. The town The court did uphold the town board's determination that it was a type 2 action. And as a result, concluded that the town had no further responsibilities to conduct environmental review. So in this case, it looks like what the petitioner was doing was arguing the specific facts of that application. And, he may have been right that there may have been some things about it that are problematic that could have potential impacts. But because this action was on that type 2 list, that ends the municipality's obligations to consider it from an environmental perspective under SECRA and to make any sort of SECRA determination prior to approving the condemnation of the easement. The next case is Williamsville residents opposed to Blocker Redevelopment LLC versus Village of Williamsville Planning and Architectural Review Board. So the developer proposed an 87-unit mixed income residential complex. The planning board conducted a SECRA review and issued a negative declaration, determining the proposed project would not have any significant adverse environmental impacts. Once SECRA was completed, the planning board granted site plan approval. So petitioners, neighboring property owners brought an Article 78 proceeding challenging the negative declaration on the grounds that the planning board mistyped the action as an unlisted action when it actually should have been a type 1 action, which, as I mentioned earlier, comes with the presumption to have at least one significant adverse environmental impact. There are also different procedural requirements for a type 1 action, including that you have to produce a full environmental assessment form. So an environmental assessment form is a form that's prepared by the DEC that is filled out at the beginning of every application that gives certain information about the different environmental areas as it relates to the proposed project, so that there can be an initial assessment as to what the potential impacts could be. There's a short environmental assessment form and a full environmental assessment form. And for type 1 actions, you're required to complete the full environmental assessment form because there's that presumption of impacts. In this case, the court said it actually should have been a type 1 action, but the applicant had only prepared and submitted a short environmental assessment form. So in this case, and the general rule is that strict compliance with the procedural mechanisms of SECRA are required. But even so, the court did uphold the issuance of the negative declaration because the environmental review conducted by the planning board was the equivalent of a type 1 review. So even though strict compliance with the procedural requirements was required, the court actually looked at the substance of, because there's procedural and substantive requirements under SECRA, and you're supposed to comply strictly with both. But so even though the procedural requirements had not been strictly complied with, the court went and looked at the substantive requirements and said, even though they had the short EAF, they did look at all of the issues that would have been in the full EAF. They presented a 31-page negative declaration that outlined all of those environmental issues that would have been addressed if it was a type 1 action. So I think for a matter of, reasonability, it didn't really make sense for the court to annul it, because rationally speaking, what would they have done? They would have gone back to the planning board, they would have submitted a full EAF, the planning board would have done the exact same thing, and then you would have just been in the same position again. So I think in this situation, the court, even though it's not really consistent with the general rule that you have to strictly comply with the procedural requirements, the court did look at the substantive requirements to assess whether to uphold the negative declaration and ended up doing so. However, in the next case of Miranda Holdings, Inc. versus Town Board of the Town of Orchard Park, which is a decision by the same court issued less than 4 months earlier on very similar facts, there was a completely different outcome. So in that case, the developer proposed a commercial development that included a restaurant with a drive-through window. While the application was pending, the town board adopted a local law prohibiting drive-through windows for businesses in the district that the developer's property was located in. The developer challenged the local law on the ground that it was improperly classified as an unlisted action instead of a type 1 action. And again, the court agreed that it actually should have been a type 1 action because one of the actions included on the type 1 list are those that change the allowable uses within a zoning district affecting more than 25 acres. And this kind of goes back to the conversation that we were having earlier of area versus use. So the town board argued that the local law didn't affect the use, but instead regulated the design properties. And the court disagreed because the law prohibited drive-through windows as they related to the use of transferring food between a structure and a vehicle, not regulating the appearance, style, or design of the drive-through window. You can argue that if you have a structure and you're just saying you can't put a window there, you could see how that could potentially be more of a bulk regulation. But in this case, because it related to the use of being able to transfer food without someone having to go into the store and get out of the car, the court found it did affect the use. And because it affected 222 acres of property within that zoning district, well more than the 25-acre limitation, it was a type 1 action. So in this case too, the court acknowledged that strict adherence to the procedural requirements of seeker is required. But unlike in the prior case of Williamsville, the court ended it there and said, town board, you were supposed to do a full EAF. You didn't do a full EAF. So you didn't comply with seeker. So your determination is annulled and you have to go back to the start of the process. And unfortunately, there isn't really a ton of information here to try to discern the distinctions. It's possible that, the town board didn't do the substantive review that the applicant in Williamsville did. So there wasn't anything for the court to rely upon to say, well, even if they didn't strictly comply with the procedural requirements, at least they went and did the substantive review that they were required to do. It also may be that the type of action that was being taken in the prior application, it was an 87-unit residential development. Here, the town board was eliminating a use from 222 acres of zoning in the property. So I can't say why the distinction, but all I can say is to the extent you're not sure, you're probably better off erring on the side of being more conservative. So if it could arguably be a type 1 action, do the full EAF just because it isn't required for an unlisted action. Often applicants do a full EAF for unlisted actions, and often boards require it for unlisted actions. So it's not unheard of. So, and it's in the grand scheme of things, it's a pretty easy procedural requirement to follow to avoid a potential pitfall like this, where you end up in litigation only to be told that the determination is invalid. Save the Pine Bush Inc. versus Town of Guilderland. So from 2015 to 2018, the town board had explored potential development options for an area of the town with an existing mall, nature preserve, and historic district, and ultimately adopted a local law creating a transit-oriented development district in the area. Under this new TOD zoning, the planning board had 2 separate developments proposals for a 222-unit residential development and 160,000 square foot Costco and gas station. So the planning board, and so the reason why I'm going through this in a little bit of detail is just to give a little bit of an overview of how the seeker process works from start to finish. So the planning board, reasonably so, looked at these 2 developments together because they were coming in at the same time. And so they needed to look at what the cumulative impacts would be, because the impacts from one may not be as great as the impacts from both. And based upon that, the planning board did issue a positive declaration, which determines that there is the potential for at least one significant adverse environmental impact, and therefore an environmental impact statement has to be prepared. So before the EIS was prepared, the planning board engaged in a public scoping process where the public can weigh in on what the scope is going to look like. And the scope is pretty much the outline or table of contents for all of the substantive environmental areas that are going to be addressed in the environmental impact statement. Once that was done, the applicant prepared the draft environmental impact statement, which addresses all of those environmental areas. And once the planning board deemed it to be complete, not that the planning board necessarily agreed with everything that was in it, but that it had substantively addressed everything that was in the scope, they held public hearings and received ample written comment on the DEIS. Then the applicant prepared the final environmental impact statement, which addresses all of the substantive comments that were raised during the public hearing on the DEIS. After the FEIS was complete, the planning board issued the finding statement authorizing the project to go forward and ended the seeker process. And then once seeker was done, site plan approval was granted. So in a first litigation, not the one we're actually talking about here, a group of town residents and business owners challenged the secret process and decision, challenging the board's determination as to several specific environmental issues, such as impacts on the avian population, visual impacts on the historic district, community character, and the required review of alternatives. Potential alternatives is something that has to be looked at in every environmental impact statement. So after looking at all of these issues, the court ultimately upheld the secret determination because finding the planning board had taken a hard look at the anticipated adverse environmental impacts and provided a reasoned elaboration of its basis for approving the project, including the remedial measures to be employed to mitigate adverse impacts. So while that proceeding was pending, that was the first litigation, the petitioners in this case, in the Save the Pine Bush case, brought their own litigation, also challenging the secret review and the site plan approval. The lower court had thrown the case out altogether and said that its decision on the prior case, the Hart case, was wholly dispositive of all issues raised by petitioner. But the appellate court disagreed with the lower court, finding that petitioners were not necessarily precluded from bringing this challenge because they weren't parties to the other proceedings, so they didn't have an opportunity to be involved and advocate for their position in that proceeding, and they were not in privity, which meaning that they had a connected or shared same interests with the first set of petitioners. However, just because they were allowed to bring the litigation doesn't mean that the court was going to start from scratch in reviewing these determinations, because the court had already reviewed this. It was a very lengthy secret process, a very lengthy, the first decision was quite long, and determined that the secret review was sufficient. So that was a binding precedent under the principle of stare decisis, that it's not going to deviate unless there's compelling reasons for it to do so, to deviate from prior precedent. So in this case, the petitioners had to demonstrate compelling reasons why the court should now say, you know what, never mind, forget what we said before, the secret review isn't sufficient. And the court said, you know what, you guys haven't done that. So what the petitioners in this case had done was they basically tried to grasp at other environmental issues that hadn't been raised in the prior litigation to try to distinguish their arguments from what had already been decided. So they focused on issues like fauna, pesticides, air quality, and wetlands. And so the court looked at all of these issues. They analyzed what the planning board had done and what the planning board had said about them. And they said, you know, there's really nothing here to change our minds on this. The planning board did what they were supposed to do. They took a hard look, which is the substantive standard under SECRA. So we're not going to disturb these findings. And so the petitioners actually did raise some other issues, one of which was a procedural issue, which, you know, I don't know how many more cases like this we'll be seeing in the coming years. This is one that I talked about last time because it was technical issues that arose from holding public hearings remotely in the early days of COVID, when we actually were not allowed to have non-essential meetings at all. So the only option in going forward was to hold these meetings remotely. Apparently during the public hearing process, there were technical issues that prevented the first 20 minutes of the hearing from being live streamed. The court noted that the video was available in real time. It was made available on the website, and people who couldn't participate were able to call back and participate later in the process. So even if there was an open meetings law violation, the court found it was unintentional and technical, and that it didn't provide good cause to annul the planning board's determination. And then the last issue that was raised, was respect to the vote of the planning board. The petitioners claimed that because one of the members had resigned from the 7-member board, that the vote was invalid. And I don't really understand what the basis for that was, but I think it's an important issue just to briefly address. But the general rule is that boards act by majority, but not by a majority of the members of the board or the members of the board present, but the majority of the members of the board for the number of members that are supposed to be on the board. So even though there were only 6 active members of this board, it was still considered a 7-person board, and therefore you needed a majority of 7. So in this case, where you had 6 people who voted in favor of it, and there was no requirement for it to be unanimous. In most cases, like I said, it's by majority. There are some situations where it has to be by supermajority, such as, you know, if you're overriding a recommendation by county planning, or if there's a petition that's been filed challenging a zoning amendment, that could require a supermajority. But in the most general situations, it's a majority. So where they had 6 votes of a 7-member board, the court found that that was more than sufficient. And then the last case on SECRA is Evans versus City of Saratoga Springs. And the city had adopted a comprehensive plan update, and based upon the plan, rezoned various parcels, including one with a hospital in a residential district, to a district that accommodated business, medical, and professional offices and related health facilities, which was basically just legalizing this pre-existing non-conforming use to allow the hospital to expand its facilities. Prior to the rezoning, the city council engaged in environmental review under SECRA, ultimately issued a negative declaration for the rezonings that they wouldn't have an adverse impact on the environment. The city council did not consider any site-specific redevelopment of the hospital parcel because they didn't want to speculate and evaluate a hypothetical expansion because nothing had actually been submitted. But once something was submitted, they explained that it would be reviewed by the lead agency and would be no less protective of the environment than a hypothetical speculative SECRA review undertaken now. So petitioners challenged the rezonings and claimed that by separating out the rezoning from the subsequent future redevelopment of the hospital, it constituted impermissible segmentation. Segmentation is another one of those scary words like spot zoning. Segmentation is the division of the environmental review of an action such that the various activities or stages are addressed as though they were independent, unrelated activities needing individual determinations of significance. Now, segmentation is not always impermissible. It's impermissible when the environmental review of an action is divided into smaller stages to avoid the detailed review called for under SECRA. So what you don't want to see is pulling out different aspects of a project, maybe to bring it under a type 1 action or to make part of it a type 2 action, so that the cumulative and collective impacts of the project don't seem as bad when you're looking at them in pieces, rather than if you're looking at the whole picture. So, but segmentation is allowed when the lead agency clearly states the reasons for supporting segmentation and demonstrates that such review is clearly no less protective of the environment, which is actually what the city council tried to do in its determination, acknowledging the need for a site-specific review when the project came in, and that it would be no less protective of the environment. But the court still found that it was impermissible segmentation. And the reason for this was because this was the first step in the hospital being able to redevelop its property. And even though the hospital had not yet submitted an application, the court found the potential for development of the parcel was not so attenuated from the zoning map to allow them to be considered separately. And the reason for this was because the hospital was out there in the press, out there talking to their donors, saying, this is what we're going to do. This is how we're going to redevelop it. So there was a plan out there. It hadn't been submitted to the city in the form of a formal application. But because the hospital was out there making known what their intentions were, and the fact that they did have a plan to construct the 3-story office building with 300 parking spaces, the court found that this was concrete enough that it should have been considered as part of SECRA at the time of the rezoning, even though there had been no application. So this is kind of a difficult outcome for the city because it puts the city in a tough position because it was trying to do all of this rezoning in furtherance of its comprehensive plan. And then, only to be told that because the hospital was making these statements about its development, now its rezoning is being called into question. But likely in the long run, it doesn't seem to be a really big deal because the hospital was going to have to do a site-specific analysis for SECRA anyway. So in all likelihood, when they did that, they would have just redone the SECRA for the zoning, approved both at the same time, And then, if petitioners wanted to challenge that, but there was a path forward because secret was still going to have to be done. And I think the court acknowledged this because the court did address the actual substance of the arguments made by the petitioner with respect to the zoning itself. Because one of the claims that they made was that it was spot zoning. So generally, if your secret determination is vacated, then everything that follows, including the zoning, would also be vacated. But even though the court said that there was segmentation with the secret determination, the court did ultimately uphold the zoning itself. So anticipating that, this may be an issue that may have to be litigated again, the court was trying to put it to bed. And in challenging legislation, the court explained that zoning determinations are entitled to a strong presumption of validity. Therefore, one who challenges such a determination bears a heavy burden of demonstrating beyond a reasonable doubt, that's the same standard as for a criminal case, so it's a very high standard, that the determination was arbitrary and capricious or otherwise unlawful. So that, as with most actions of municipal boards, but even more so, a legislative action by the board is entitled to very considerable deference with respect to its propriety.
Before we move on to wireless telecommunications, there's kind of a general question. How soon after a zoning change is it tenable for an applicant to ask for a variance?
I mean, once the zoning is in place, you can absolutely ask for a variance. It's kind of hard to be the first one to come in right after a zoning text amendment or a zone change has been put in place. And then you're coming in and asking for relief from that provision that's just been enacted. So I think you would need to have a good argument as to why it's needed under those circumstances. But there's no rule that says, for 2 years or however long after a zone change or a zone text amendment is put in place, you can't seek relief from it. That's something that you're always afforded the right to do, is get a variance or seek a variance under the zoning code.
I imagine if the zoning change was to relax bulk standards tremendously, now you're coming in and getting a variance of those now newly relaxed bulk standards. Yeah, you might be met with some skepticism, but
yeah, you would need to demonstrate why you need it. And like I said, if it's something that's just been enacted and something that's just been looked at, because any zoning text amendment or zone change is going to require secret. So if that's something that's just been analyzed and determined by the legislative board that those are the appropriate standards, and then the next day you come in saying, I don't want to meet those standards, or I can't meet those standards, I think you would really need to demonstrate why that's necessary under those circumstances. Because what we see in a lot of municipalities is that a lot of properties are legal non-conforming as to bulk. Properties are upzoned, bulk requirements change after, principal residential structures have been constructed. And so, that's a need for variances. But if it's something that's recently been adopted, I could see why it may be a little bit more challenging to convince a municipality that you need to deviate from those requirements. Anything else?
no, that's it for now.
Okay. Okay. Wireless telecommunications. So I actually, in my discussion, I switched the order. So I am going to talk about Verizon Wireless of East LP versus Town of Wappinger first. And so with telecommunication cases, timing is often very important because the Federal Telecommunications Act and the FCC orders prescribe a certain period of time, which is deemed presumptively reasonable to process an application. It's 90 days for a personal wireless service facility, citing applications requesting co-location, and as applicable to this case, 150 days for all other applications. And this is called the shot clock, that presumptively reasonable time for a municipality to process and decide an application. So in Verizon, in October 2019, plaintiff made an application to the town for a proposed 150-foot tall monopole cell tower. after making several subsequent submissions at the request of the planning board and its consultants, the application was deemed complete on December 23rd, 2019. And that completion date is important because that's what starts the shot clock. Before the application is complete, there are certain requirements the municipality has to meet in terms of the time within which to review and notify the applicant if it's not complete. But once it's deemed complete, then the shot clock, in this case, 150 days starts. So in March 2020, the planning board retained a wireless telecommunications consultant to review the application. And after corresponding back and forth with the applicant a few times, the consultant was satisfied that the application was complete and acceptable. And then 2 months later in May, the planning board called for a public hearing. And even though the planning board was coming up on the 150-day shot clock, which is approximately 5 months, the applicant believed that the planning board was acting reasonably and expeditiously, especially because in light of the early days of the pandemic. And so they agreed to extend the shot clock. And that's a common occurrence, that the applicant will agree to extend the shot clock, because sometimes for reasonable reasons, it does take longer to consider and decide these types of applications. And so most of the time, the applicants are reasonable in recognizing that and noting that it's more productive to work with the municipality to get to the ultimate end result of getting your approvals, rather than ultimately running to court and delaying for a year in time and expense, where, the court's probably not going to be incredibly sympathetic if you're not willing to give the municipality some latitude. So they held a public hearing in May 2020, and there was ample opposition to the project. After the public hearing, the applicant made a supplemental submission addressing the comments from the public, and the town's consultant also responded to the comments that were raised by an attorney representing the homeowners and refuted those claims. So you had consultants for the applicant and the town all refuting the public comments that were being made. And then at the continuation of the public hearing on July 6th, the planning board directed its planner to draft a negative declaration, which is a finding that there are no adverse environmental impacts and which would end the secret process. The draft negative declaration included several paragraphs explaining why the cell tower would not have a significant adverse environmental impact on scenic or aesthetic resources. However, at the July 20th public hearing, the planning board decided to close the public hearing, but instead of voting on the negative declaration, asked the applicant to provide additional information, including an analysis of visual impacts, a real estate appraiser's report on the impact of the cell tower on local property values, and clarification on alternate locations, all issues that had been addressed earlier in the process and all issues that had been signed off on by the town's consultants. And then the planning board chair sent a letter to the applicant advising that the visual tests were defective, which was an issue that had been raised for the first time over 7 months after it was first submitted. Again, the applicant agreed to extend the shot clock, tried to work with the planning board, providing them with additional information. And at the September 9th meeting, the planning board then reversed course and directed its staff to prepare a positive declaration, which would require the preparation of an environmental impact statement. And the planning board ultimately adopted that positive declaration in September, which resulted in the plaintiffs filing this litigation, alleging that the town had violated the shot clock. So the court explains that the Congress enacted the Telecommunications Act to promote competition and higher quality in American telecommunication services and to encourage the rapid deployment of new technologies. One of the ways Congress did this was to reduce impediments imposed by local governments by putting limitations on traditional land use authority. And I'll talk a little bit more about that in the next case. So then the court went through the different claims that the plaintiffs had made. The first was the failure to act within a reasonable period of time, violation of the shot clock. While the court acknowledged that the 150-day presumptively reasonable time period may be subject to change in certain circumstances where the municipality legitimately needs more time, it found that plaintiff had established under this pattern a presumption that the town's actions and the time it took them to take those actions were unreasonable. The court also noted that since the litigation was commenced, the town had stopped processing the application, which the town claimed was standard procedure, but which the court found was not supported by the TCA. And so since the plaintiff had established the presumption that it wasn't reasonable for the town to violate the shot clock, the town did have an opportunity to rebut that presumption. And the court basically rejected all of the town's reasonings. The town argued that it needed time to retain a consultant to review the project, but the consultant had conducted his review a month before the original shot clock had expired, and therefore the court found that unavailing. They also raised COVID-19, claiming that it took more time to process the application because of the pandemic. The court also rejected this because the shot clock was pretty much halfway done at the time that the pandemic hit. The town had also started conducting its hearings remotely. So that demonstrated that it was feasible for the town to consider keep moving the application forward, which they actually did. They held a public hearing in May, which, was still very early on when you really couldn't hold any non-essential meetings. So the court rejected that as well. And then the town also argued that after the public hearing in May, when it was basically overwhelmed by concerns from the property owners, raising visual impact concerns that hadn't previously been addressed. But the court rejected this too, because the visual impacts had been discussed and the applicant had made several submissions to address it before the public hearing was opened in May. In addition, the public hearing was opened pretty much at the time that the shot clock expired, and the planning board and the applicant did agree after that time to extend it. So the board did have an opportunity to address those issues. They just chose not to do so, instead issue the positive declaration. So the court explained that the FCC doesn't just require the planning board to take action on the application. So because what the planning board did, right, is they issued the positive declaration. So they did take an action. They determined this is, it has the potential for at least one significant adverse environmental impact. So go prepare your environmental impact statement. The court said that that wasn't the intention of the shot clock under the FCC regulations, because that would pretty much defeat the purpose of having the shot clock in the regulations. If you could just drag it out for almost a year, well beyond the shot clock, and then make a determination that's going to necessarily cause the process to go on for another year or two, at least, if you then have to do an environmental impact statement. And the court found that under these circumstances, the positive declaration was a pretext to further delay the application, especially in light of the history. And that to accept the town's argument would mean that local boards could indefinitely delay an application with a flurry of hearings, requests, and counter submissions that mask a denial. Lastly, and this was a big substantive difference, the court looked at the positive declaration versus the negative declaration that had been drafted for the board's consideration. And the substance of the negative declaration was much more valid and legitimate and had substantive analysis justifying its decisions, whereas the positive declaration that the board ultimately adopted was all conclusory statements that were found to be unreliable and didn't pass muster. So basically, it was determined that the town had violated the shot clock. Plaintiffs separately claimed that the town's actions violated the FCC rules that ineffectively prohibiting wireless services, but the court rejected this argument since the planning board hadn't actually made a determination. So another thing you're not allowed to do is to prohibit or take action that effectively prohibits wireless telecommunications facilities. Because the town hadn't actually made that determination yet, the court couldn't say definitively that they had done so. What the court did say is, hey, town, you need to move on this. You have 60 days to make a decision. And so then it was sent back to the town. And I guess we'll wait and see what happens. So the next case is Extent Systems LLC versus Village of Kings Point. Plaintiff had submitted an application to install 31 small wireless facilities in the village. Small cells are like they sound, like the description, they're small. They're only 2 to 3 feet in height, with equipment boxes that are attached to existing utility structures in public rights of way, which have a more localized service radius in the hundreds of feet. This is different than macro towers, which I think is what most people think of when they think of a cell tower that can be over 100 feet tall and provide service for miles. So plaintiff contacted the village about this proposal in 2017 and first appeared before the board, the village board, which was responsible for granting a special permit in 2018. At that meeting, the board members and the police commissioner actually acknowledged that there was unreliable wireless service. So the applicant began working on an application and got approved in March of 2019. However, after work commenced, the building inspector actually revoked the special permit, which I question whether that was something he was actually allowed to do. And also issued a stop work order because apparently, allegedly, the applicant wasn't adhering to the specifications and antenna models of what had been approved. Whether that was a pretext to stop the project or not, I don't know. But project was stopped. The applicant ended up making another application that was put on hold for a period of time, again, due to the pandemic. By the time we get to February 2021, all that's left to do is schedule the public hearing. Again, like with the Verizon case, the public hearings were very contentious. And the court actually made note of the fact that board members were yelled at by members of the public and accused of working for plaintiff, the wireless provider. So after the shot clock deadline, the board unanimously denied the application without prejudice for the plaintiff to make another application. And there were 31 nodes at issue. With respect to 5 of them, the village actually took the position that they couldn't approve that because it was on a private right-of-way, not a public right-of-way, and so they couldn't authorize that. So plaintiff brought a lawsuit challenging the denial and seeking injunctive relief to direct the village to issue the approvals. And to do that, the applicant first has to demonstrate irreparable harm, which the court found that they did by demonstrating that it's been nearly 5 years since the property owner had first made since the applicant had first made the application to the village, and that because of this delay, they have suffered and will continue to suffer indeterminate harm, and that this is a harm that cannot be accurately remedied through monetary damages, because you can only get an injunction if money can't make you whole. So here, it wasn't just about, the loss of business. It was about the loss of providing the service, and it's unquantifiable to determine what the value of that loss of business was. The other thing that has to be determined is the likelihood of success on the merits in order to be entitled to injunctive relief. And the court explained that the function of the TCA is to preserve local authority over decisions regarding the placement, construction, and modification of personal wireless services, but limits local government from taking actions that prohibit or have the effect of prohibiting personal wireless service. So in order to avoid that, the procedural standard that boards must satisfy is any denial of an application has to be in writing and supported by substantial evidence. In this case, it was a special permit that the applicant was seeking. The applicant wasn't actually seeking a variance. And so that, as we discussed earlier in the special permit standards, a special permit, that a use that's determined to be allowed by special permit is tantamount to a finding that the use is harmony with the general zoning plan and will not adversely impact the neighborhood. And the village actually acknowledged that the applicant had complied with all of those special permit requirements. So generally, when you're seeking a variance for a wireless facility, you have to show public necessity. Is there a need for this? Is there a gap? Is there coverage that's needed? The applicant actually made a compelling argument that they didn't have to show public necessity because they weren't seeking a variance. They were only seeking a special permit, which is a different standard. And the court was kind of persuaded by that, but ultimately said, I'm not going to decide that issue because you actually did satisfy the public needs standard. So I don't really need to go there. And so then the court looked at the evidence that the applicant had presented to demonstrate that there was a need for the small cells. The applicant demonstrated there was a gap in coverage, and this was demonstrated through coverage and drive test maps and engineering testimony, that small cells would remedy the gaps and that installation would be a minimal intrusion to the community. Meanwhile, the court found that the board's claims were not supported by the record and contradicted prior statements by the board that there were gaps in coverage. Instead, the court noted that the board's conclusion was based upon anecdotal comments from the residents, statements by one of the residents' attorneys interpreting Verizon's coverage map, and plaintiff's refusal to provide underlying data to the board. And the court found this to be insufficient to provide substantial evidence to justify denying the application when weighed against the evidence provided by plaintiff. The court also recognized that under state law, which had been cited in federal courts previously, it's impermissible to deny a special permit based upon allegations or claims that the approval would violate the private rights of the third party. So with respect to those 5 nodes where the village said, well, we can't approve this anyway because it's on private property and we can't authorize that, there's actually case law that says that's not your role, village. You're just approving the use. And then, that's a private issue that has to work itself out independent of the village. So lastly was the balance of the hardships. And the court ruled the balance of hardships weighed in plaintiff's favor, where plaintiff worked in good faith with the village and the residents for years to address concerns, granted multiple tolling requests, and ensured there was minimal intrusion to the community, while the village did not demonstrate that there were any negative impacts to the health of residents or the value of their property. Those are the big issues you generally find when you're dealing with wireless facilities. Potential health concerns, which have been dispelled in numerous studies, diminution of the value of the property, as well as visual impacts. And so the court rejected all of that in this case and ultimately ruled that the village was required to grant the special permit to allow the use.
All right. I'm going to interrupt real quick just to give the fourth and final attorney affirmation attendance verification code word, and that is going to be candy. So this weekend, make sure you go out and buy some candy because Halloween's coming up. All right, that's our final code word of the evening. And there is a question: if a small cell on a public right-of-way can be proved harmful to an individual and/or health on private property, could this be denied?
I would like to see what that evidence would be, because this is something that wireless communications facilities have been dealing with for years and years, and they have tons of studies to support. I'm not a doctor, so I can't say definitively, but it's pretty much a rule that you can't raise health issues because as a concern, because it does it. All of the evidence and all of the medical research doesn't support that there are any impacts. If there were impacts and that was demonstrated, I would think so, but right now the status of the research and the law is that there are no health impacts. So I think right off the bat, whenever these uses come in, they come in with their studies and they hand them to the village showing, look, here are all the studies saying there's no correlation between wireless facilities and adverse health impacts.
Is that written into the federal law?
It's definitely in the case law. I would need to look at that. I can take a look. It's a lengthy law.
All right. Well, I don't have any more questions after that at the moment.
Okay, so what I'm going to do, I'm going to do these first 2 cases, which aren't too long. And then the last case is a carryover from last time. So for those of you gluttons for punishment who were here in May, you already heard me talk about this. So hopefully I can wrap this up before 9 o'clock. Congregation Rabbinical College of Tartikoff versus Village of Pomona. So, this has been going on for a long time. I keep tabs on it, and whenever there's a new update to provide, I always make sure to include it. So we do have an update. This has been going on for about 2 decades at this point. Previously, the Second Circuit Court of Appeals, which is the court that issued this decision, upheld 2 laws enacted by the village in 2001 and 2004, regulating educational institutions and related dormitories. In its prior decision, the Second Circuit noted that plaintiff never submitted a formal proposal for the building project, applied for a permit, or engaged in any other conduct that would implicate or invoke the operation of the challenged zoning laws. Whatever harm may arise from the application of the zoning laws to plaintiff's property is merely conjectural at this time. As a result, the court determined it lacked jurisdiction over plaintiff's claims. So what the Second Circuit said was, we need something more concrete about what you're proposing, because right now, any harm to you is conjectural. So after that, the plaintiffs actually brought another claim under RLUIPA, and we talked about the Southern District decision last year or earlier this year. And so this time the petitioners did bring a zoning petition proposing changes to the zoning text. However, it wasn't specifically related to a proposed development plan for the use of their property. Instead, it was just a zoning text amendment to completely abolish and repeal those two laws. And so the petitioners tried to use that as a path to say, okay, you wanted us to file a petition, we filed a petition. So now we can challenge this. And the court rejected the petitioner's arguments about why this should be any different, and again determined that it lacked jurisdiction to hear the plaintiff's claim. So the first thing the plaintiff relied upon was the zoning petition that it had filed to repeal the law. And the court said because it was not related to the proposed land use, the village's refusal to consider it could not be considered to be a final decision on plaintiff's particular development plans. Therefore, as with the Southern District's decision, there was no final determination or concrete injury, so the claim wasn't ripe and plaintiff didn't have standing. The plaintiff also cited to a recently decided U.S. Supreme Court case from 2021. That's the case of Pactel v. City and County of San Francisco. And plaintiffs argued that this case eliminated the requirement that there be at least one meaningful application and final decision made on said application prior to bringing the lawsuit. And the court rejected this interpretation, saying that it did not stand for what plaintiff purported, and that there were substantial factual differences between those two cases. So in Pactel, the city had refused specific requests to excuse plaintiffs from compliance with certain land use regulations. Therefore, the city had committed to a position on the desired land use, and plaintiffs were injured by the city's action by rejecting those requests. Here, the village had not committed to a position on plaintiff's desired land use because plaintiff hadn't presented it to the village. Because again, the petition related just to amendments to the code generally, and not to the use of the property itself. So the court maintained, or the implication is that the court maintained its position that until plaintiff makes a site-specific land use application for the village to rule on, it's unlikely plaintiff claims are going to survive in court. And then the last case really quickly, Allentown Victory Church versus City of Allentown. So plaintiff is a non-denominational nonprofit church that operates an all-male Christian facility for individuals recovering from drug and alcohol addiction. Residents of this facility attend religious services and AA and NA meetings. The home is located in a residential district, and it came to the city's attention that they were operating without the proper approvals and permits. So plaintiffs sought approvals to continue the use under several different categories of the code, but the zoning board ultimately determined the use was most appropriately characterized as a halfway house, which was not a permitted use, and therefore the application was denied. Plaintiff brought claims under the Federal Fair Housing Act, the Americans with Disabilities Act, and RLUIPA. So specifically as it relates to RLUIPA, plaintiff claimed by denying the application, the city imposed a substantial burden on its exercise of religion. So the law on that is that RLUIPA provides that no government shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person, including a religious assembly or institution, unless the government demonstrates that the imposition of the burden on that person, assembly, or institution is in furtherance of a compelling government interest and is the least restrictive means of furthering that compelling governmental interest. And religious exercise is also very broadly defined as any exercise of religion, whether or not compelled by or central to a system of religious belief. So in this case, you have two issues. Was it a substantial burden? And was what the applicant was doing on the property actually under the definition of religious exercise? And the court didn't go into a lot of detail on it, but it seems that its perspective was that it was neither. And the reason for this was because even though the court did acknowledge that it was a noble mission and a noble activity that the plaintiff was engaged in, and that these recovery facilities were essential role to society. Under the law, there was no substantial burden on plaintiff's religious exercise that could sustain an RLUIPA claim, because plaintiff didn't cite to any facts to demonstrate that the board's decision forced plaintiff to choose between following the precepts of its religion or forfeiting benefits otherwise available to another similarly situated person, or that the board applied substantial pressure on plaintiff to substantially modify its behavior and violate its beliefs. So basically, the implication is, by denying their application, it was no way impacting the religious use of the religious practice, because this use wasn't really directly related to that. So the court upheld that. Okay, sorry. So I think I'll end here. Like I said, the last case, Woodcliff Lake Citizens against Overdevelopment. I talked about that one last time. And the summary pretty much wraps it up. So.
All right. All right. Well, since it's about 2 hours after we started, a little after 9 o'clock, I think it's a good place to start wrapping it up. So first, thank you very much, Christie. I truly appreciate all the time and effort you put into these presentations. And I'm always impressed by your ability to cover so much material while at the same time taking this very dense subject matter and making it accessible for everybody.
Thank you.
And to everyone else, serving on the land use board is a largely thankless job. So thank you to all you board members out there. Thank you for being here tonight, and for every other day and night that you give up to serve your community. And if you're not a member of a board, thank you for coming as well. I hope everyone found this session informative and enjoyed it. All webinars from the Federation are saved and are uploaded to a YouTube page. Everyone will be getting an email after this as a requirement for CLE, for me to issue CLE credit. It's only for attorneys to respond to, but I will include in that email the link to our YouTube page so you can get a recording. Once again, if you're on a board outside of Rockland County, you need a certificate of attendance, please send me an email, which I've put in the chat a couple times. And that's it. I see one question. I'm going to see, oh, it says, thank you. This was great. Well, that's an easy question to answer. All right. With no more questions, we'll call it a night. Thank you, Rich, for standing by. I'm glad you didn't have to do anything. And again, thank you, everyone. And thank you very much, Christie. As always, this was great.
Thank you, everyone. Have a good night.
Good night.